What are the legal arguments for the mercenary loophole in IHL? Imagine a world where fighting in conflicts could be done without clear rules, where some actors slip through legal cracks. That's what the so-called mercenary loophole is all about in international humanitarian law. To understand it, we need to look at how IHL, or International Humanitarian Law, defines and regulates mercenaries. The main rule comes from Article 47 of Additional Protocol 1 to the Geneva Conventions. This article gives a detailed, 6-part checklist to identify who is a mercenary. It says a mercenary is someone recruited specifically to fight, motivated mainly by money, not a national or resident of the conflict party, not part of the armed forces, and not sent by a non-party state on official duty. All 6 conditions must be true for someone to be called a mercenary under IHL. This strict list makes it hard for many private military personnel to be classified as mercenaries. For example, many private military and security company staff are nationals of the conflict party or are officially part of the armed forces. Because of this, they don't meet all the criteria. So, even if they are fighting for profit, they often fall outside the legal definition. And this is where the loophole begins. Since being a mercenary isn't a crime under international law, most of these private actors are not automatically covered by special rules. They are entitled to humane treatment if captured, but they are not considered mercenaries and don't get the same legal protections or obligations. Prosecuting mercenaries depends on the national laws of the detaining country, not on international law. This means that if a country does not criminalize mercenary activity, these fighters can operate with little legal risk. Because the definition is so narrow, many individuals who are clearly motivated by profit and involved in conflict are not legally labeled as mercenaries. This creates a gap where private military companies and similar actors can work in conflict zones without triggering the specific rules meant to regulate mercenaries. This situation affects how conflicts are managed and how civilians are protected. The law aims to be clear and limit the scope of who is considered a mercenary, but critics argue that it is too tight. It allows some harmful activities to go unpunished because they don't meet the strict criteria. Many call for broader international laws that would criminalize mercenary activity more effectively and close this loophole. Today, most private military actors are regulated by national laws and contracts, not directly by international humanitarian law. This can make it harder to hold them accountable and protect civilians. The legal arguments for the mercenary loophole rest on the strict language of the law, which makes it difficult to classify many profit-driven fighters as mercenaries. Because of this, many activities that seem similar to mercenary work are not covered by the special rules of IHL. This creates a legal gap that balances the clarity of the law with its limits. For those concerned about civilian safety and the integrity of the laws of war, this loophole shows both the strengths and weaknesses of current international law in dealing with non-state actors in armed conflicts.